I think we just have people enter now, so just give it a minute to let everyone get in. Okay, looks like we might have everyone in now, so I think I'll kick off. Good afternoon, everyone. You're all very welcome to the fourth and final webinar in the Four Families series, webinar series dealing with a range of legal issues affecting LGBT plus parents in Ireland. Just to begin with a bit of housekeeping, I'm sure people are well used to Zoom webinars at this stage, but just to ask that everyone ensure that their microphones and cameras are turned off, and just to note also that this session is being recorded. Okay, so now that that's dealt with, just for those of you that don't know me, my name is Tony Ross. I'm an associate solicitor in Matheson and a member of the Outlaw Committee. The Outlaw Network was formed in 2018 with the aim of promoting the inclusion of LGBT plus individuals working across the legal sector in Ireland. And we welcome those from any facet of the legal sector, whether that be those working in any capacity in legal practices, in legal roles in industry, and students who are working towards careers in the legal sector, both members of the LGBT plus community and allies. Outlaw also host events on legal topics of interest to the LGBT plus community, and we're absolutely delighted to have partnered with our good friends Equality for Children, who are jointly hosting this webinar series with us. We're going to be joined a little bit later on by Maeve Delargy, who'll be wearing both her Outlaw and Equality for Children hats, and Garrod Kenny Moore of Equality for Children, who will be looking at the personal side of how these issues impact on LGBT plus parents. But first, just to kick us off, I'd like to introduce our legal speakers, Surrogacy for Change. We're joined by all four founding members of Surrogacy for Change, Jack Swain, who is a legal executive in Beale & Company, Aoife Byrne, LLM student in Trinity College Dublin, Jack Loftus, secretarial assistant in Shannon Aaron, and Yasmin MacDonald, a student at the Honourable Society of the King's Inns. So I'll pass it over to you now, folks. I think Jack is going to kick things off first. I am also going to share my slides and cross my fingers while I do it. Okay, if somebody could just let me know when we see it. How are we looking?
There you go. Got it.
Thanks. Over to you, Jack.
Great. So good morning, everyone, or good afternoon, I should say. So I'm Jack Swain, a founding member of the Surrogacy for Change group, along with my colleagues Jack Loftus, Aoife Byrne, and Yasmin MacDonald. Now, just a brief background about ourselves. Surrogacy for Change was formed by the four of us in 2018 in response to the dire need to reform surrogacy law in Ireland. As a group, we recognised the lack of any sort of effective protective framework in place, and we sought to lobby various government departments to effect some long overdue change to this area of the law. Since founding Surrogacy for Change, we've thoroughly researched surrogacy law from a domestic and from an international perspective, and we've become immersed in the issues faced by surrogate families. And in full of that, we drafted an in-depth law reform proposal, which has been put to the government. And within 4 hours of submitting our proposal to the government, we had some of the major political parties looking to sit down with us and discuss the need to reform this area. And I think that really highlights that the government recognised the need to properly legislate for the regulation of surrogacy in Ireland. And we've met a number of TDs over the last year or so. Most recently, we've had engagement with TDs from the Oireachtas Committee for Health and Children, with whom we've discussed our proposals and whom in turn actually have pledged to put further reform onto the programme for government. Now, what does further reform mean? Well, that's the golden question, and it remains to be seen what's actually going to manifest from any of this. But we can only hope that they're listening to the lobby groups like ourselves, and there are many other lobby groups, and that they're taking account of the experiences of those directly affected by this area when they're drafting any future legislation. So what is the current position with surrogacy law in Ireland? Well, the stark reality is that there's a complete lack of any solid form of legislative provision. As Ireland has moved to become a bastion for social justice through the passage of the same-sex marriage and abortion legislation, it just seems a shame that surrogacy is being left behind. So that brings me to the question of, well, what is the law? Well, currently the only piece of legislation which remotely deals with the issue of surrogacy is the Child and Family Relationship Act 2015, which provides for assisted human reproduction, but it doesn't really cover anything to do with surrogacy. Now, under the 2015 Act, there are no contractual provisions to regulate surrogacy agreements, and no protections in place to render any surrogacy agreement enforceable. And this is what our submission to government seeks to introduce. The submission sets out the need for an enforceable system of commercial surrogacy contracts, while also offering traditional non-enforceable surrogacy agreements, as well as the introduction of protective legislation similar to that already in place in California. And to move on from our submission, in simple terms, what is surrogacy? Well, there's 4 definitions. I think they might be on the previous slide, or maybe the one before.
Sorry about this now. Can't go back. I'll get around to it. You can continue on there.
So there's 4 main definitions. So first of all, you have traditional surrogacy. Now, with traditional surrogacy, the surrogate mother is the biological mother. The intending father's sperm is artificially inseminated, and this usually arises where the intending mother can't conceive naturally. You then have gestational surrogacy, where a woman agrees to become pregnant and give birth to a child for another person. Then you have altruistic surrogacy. Now, this is a non-enforceable surrogacy arrangement, whereby the surrogate is completely unpaid for carrying the child. And altruistic surrogacy is the current position in Ireland. Finally, then you have commercial surrogacy. This is an enforceable surrogacy arrangement, whereby a surrogate mother can be paid. She can also not be paid, depends on the terms of the agreement, but she can be paid for her service for carrying the child for the intending parents. The surrogate mother has no parental rights over the child, as all the rights stay with the intending parents, i.e. the parents that actually intended to create that child in the first place. So let's look at the current legal framework in Ireland, which I think is the next slide. So under the Child and Family Relationship Act 2015, and you'll see from the slide there, the surrogate mother is the legal mother of the child. Her husband or civil partner is the legal father of the child, despite having no genetic link with the child. The biological father can rebut this presumption through a DNA test. However, the intended mother or intended co-father can only establish a legal relationship with the child once they have shared day-to-day care with the child for 2 years. And 2 years is an awful long time if you ask us. Further from that, then, the surrogate mother has all the decision-making power until the child is born. The surrogate mother can decide not to relinquish her rights once the child is born. And finally, the intending parents who intended to create the child can only become the legal parents of that child through adoption, despite having half the genetic links to that child. And that brings us on to the need for reform. So, as you can see, the current provisions of the 2015 Act, they're not exactly expansive when it comes to surrogacy. And this is why we need to reform it. So what kind of reform am I talking about? Well, given the time constraints of this particular webinar, I can't go into the detail that I'd like to get into, because this really is an area that's crying out for reform. But put simply, the reform is needed to protect the rights of the surrogate, to protect the rights of the intending parents, and to protect the rights of the child. And the most effective way to achieve that maximum protection is through proper regulation. Now, proper regulation can't come through a half-hearted act that's been passed in a rush. This area needs serious thought and serious reform, and it needs progressive reform. Now, Jack and Aoife are going to cover the provisions of the new bill, but any light read of the new bill makes it evidently clear that it was drafted by people who appear to be utterly unaffected by the lapse in the legal system. And despite their best intentions, and without meaning to criticise their work, because they've done good work to date, in fairness to them, and they've put a lot in it, but at the same time, they don't appear to have a strong enough comprehension of the real-life challenges faced by surrogate families and how to tackle them. That's problems around the surrogate mother not relinquishing her rights to the child, the intending parents having to start all over again, the problem of surrogate parents having to travel abroad to surrogacy clinics that often can be completely unsafe and completely unsuitable, the ability to get a passport then for the child to bring it home, and so on. And you'll see on the slide there that Ireland ranks second highest out of 90 countries in the world for the use of foreign surrogacy. And that figure speaks for itself in showing how seriously reform is needed here, because the surrogate children born abroad are being left stateless. What do I mean by they're being left stateless? Well, they don't have citizenship there, they don't have citizenship here, and they have to apply for it. And people often say to me, oh, but sure, you know, this surrogacy stuff, it only affects the parents. Isn't the child fine when it's all said and done? Well, as a matter of fact, no, the child is not fine. The child might be healthy, and the parents might be happy, but the legal system leaves that child stateless. And this lapse in the legal system raises serious issues when it comes to the registration of travel documents and citizenship. And ultimately, in many instances, applications end up being brought to court to challenge the stateless standing of that child. And that just adds to further stress and costs for the intending parents. So while the proposed bill does seek to regulate surrogacy in some form, unfortunately, it just doesn't go far enough. And just looking at the clock, I'm probably gone a little bit over on my time now, so I'll pass over to Aoife.
Hello everyone, hope you can hear me okay. My name is Aoife Byrne and myself and Jack Loftus will be discussing the proposed bill on assisted human reproduction. The general scheme of the IHR Bill was approved by government in October 2017, and an important aim of this legislation is to promote and ensure the health and safety of parents and children born as a result of IHR treatment, as well as other parties who may be involved, such as donors and surrogates. In this regard, consideration of the welfare and best interests of the children born through IHR is a key principle underpinning the scheme. The general scheme also provides for an independent regulatory authority for IHR. Part 6 of the IHR Bill elaborates on surrogacy, which domestic surrogacy, meaning a surrogacy agreement undertaken by a surrogate and an intending parent who are habitually resident and where the embryo transfer is carried out within the state. Surrogacy agreement means an agreement under which a woman agrees to attempt to become pregnant and, if successful, to act as a surrogate and to transfer the parentage of any child born as a result of the pregnancy to an intending parent or intending parents. Head 36 of the IHR Bill provides that surrogacy may be permitted if it is a domestic surrogacy, gestational surrogacy, non-commercial surrogacy. The surrogacy agreement has been approved in advance of treatment by the regulatory authority. If the surrogacy meets the requirements set out by the bill, if each intending parent or intending parents together meet the requirements of this bill, and if each intending parent and the surrogate provides his or her consent. I think I'm 2 slides ahead if you just want to follow, so it's easier. It's a bit fast now. Head 38 of the bill outlines the necessary requirements and conditions for a surrogate to enter into a surrogacy agreement. A woman may act as a surrogate as part of a surrogacy agreement only if she is habitually resident in Ireland, has previously given birth to a child already, is at least 25 years of age at the time of the submission of the application for authorization for the surrogacy agreement, and is 47 years of age or under at the time of the embryo transfer as part of the surrogacy agreement. While also prior to the submission of the application for authorization was assessed and approved as suitable to act as a surrogate by a registered medical practitioner and also by a counsellor. While we support the proposal of the requirements for assessment and approval by a registered medical practitioner, we do not endorse the restrictions of age prescribed by this bill. We believe that an age limit is excessively restrictive and should only be considered should there be issues raised by the medical practitioner or counsellor, as well as the minimal age requirement, which we believe should be 18 years of age. In addition to this, as detailed in the following heading of the bill, it is stipulated that intending parents must be of 21 years of age. We also believe that this age should only be considered and decided by the counsellor. We also believe the requirements for a surrogate to have already given birth to her own child is unnecessarily far-reaching and another excessive restriction set out by this bill. Head 40 of the bill provides that all commercial surrogacy agreements are prohibited. A surrogacy agreement will be considered to be commercial in nature if any person receives or agrees to receive any payment or any other reward in consideration of entering into a surrogacy agreement. This section, however, does not apply to a payment or any other reward that is reimbursement for reasonable expenses. We propose to allow full commercial surrogacy similar to the model that exists already in California, which Yasmin will further discuss later. Head 41 of the bill discusses the surrogacy agreements and reasonable expenses and states that an obligation under a surrogacy agreement to pay or reimburse the surrogate's reasonable expenses is enforceable only if the surrogacy agreement was made prior to the transfer of the embryo to the surrogate. These reasonable expenses can be associated with any of the following matters that are part of the surrogacy agreement, such as the pregnancy or birth, any expenses involved in entering the agreement, such as counselling expenses or legal advice, any prenatal or postnatal expenses associated with the pregnancy. And finally, head 43 of the bill then outlines the proposed requirement for counselling and independent legal advice. This proposal implies that the surrogate of each intending parent involved shall have received counselling regarding the potential social and psychological implications at each stage of this surrogacy agreement, and may also receive legal advice and information about the legal implications of the surrogacy agreement prior to consenting to this agreement. The legal advice received by the surrogate should include her husband where applicable and shall be independent from the legal advice received by the intending parent. We fully endorse this proposal for mandatory counselling and legal advice to ensure the safety, security and comfort of all parties involved, and we believe it should be a necessary requirement in all surrogacy agreements going forward. Jack will now follow on with the remainder of the bill in relation to surrogacy.
Good afternoon, everyone. Thanks, Aoife. I'm following on, and I know we're very tight for time, so I'm going to try and keep this brief. I'm going to deal with three specific elements of the proposed AHR bill, specifically the information for the regulatory authority, the National Surrogacy Register, which proposes, and parental order reforms. So as Aoife has kind of alluded to, we would propose that much of this bill represents a wholesale and at times egregious misunderstanding of what it is that those who will be directly affected, many of whom I know are actually on this call, are looking for. And at times it appears to be completely out of sync with successful precedents which have been established in other jurisdictions, which I know Yasmin is going to talk about a little bit later. So to begin with then, the information for the regulatory authority. So under heading 44, section 1 sets out that prior to giving his or her consent to the surrogacy agreement, the surrogate and each intending parent involved should be informed that A, the surrogate will be the legal mother of any child born as a result of the surrogacy agreement. B, that the surrogate's husband, if she has one, will be presumed to be the legal father of any child born as a result of the surrogacy agreement, unless the contrary is proven on the balance of probabilities. And section C states that an intending parent will not automatically be the legal parent of any child under the surrogacy agreement. So I think I should probably outline this from the beginning. So we do not believe that intending parents should have to assert their parental rights or be forced into a legal process to determine something that we believe should be outlined from the very beginning of a surrogacy contract. We would support that the entering into the surrogacy agreement automatically grants parental rights to the intending parents rather than the surrogate mother, and certainly not for her husband if she has one. So then to move then to the second kind of part of what I'm going to be discussing, which is the National Surrogacy Register. So this is also contained within heading 44. It outlines the establishment of a national register where the information of both the surrogate and the intending parents will be held. Section E states that the information specified will be recorded in respect of the surrogate, each intending parent, a child born under the agreement, and where applicable, the donor of a gamete used to create the embryo that was transferred under the surrogacy agreement. This section is a little bit more complex. So in spite of what I've said before about this bill and its many kind of pitfalls, we would support the foundation of something along the lines of the National Surrogacy Register. And we would support that in the context of the recent stories we've heard about adopted children and their difficulty in obtaining information about their parentage. Though every child may not wish to seek this information, and this would only be done, of course, when they turn 18, we believe that they do have a right to access that information should they wish, and that it should be their right should they wish. You know, we also recognize that in reality, oftentimes the relationships between the surrogate and the intending parents are one that is quite close, and that this would not necessarily be something that is crucial. But as I've said, we would support, in principle anyway, the founding of something such as a National Surrogacy Register. So then on to the final section that I want to discuss, and that is this issue with parental order reforms. If you can just go on to the next. Sorry, Tony, it's just the one after that then. Yeah, so this is contained within heading 45 then, and it states, section 1, that an application may only be made to the court of parental order in respect of a child who was born under a surrogacy agreement that was permitted under heading 36. And that unless the court directs otherwise, the following persons shall, in accordance with regulations, be served with a notice of the application. And if the surrogate makes an application, each intending parent named in the application, the surrogate's head, where applicable, the Attorney General, and any other person that the court considers appropriate. So once again, to reiterate what I've said already, this is a persistent issue that we witnessed in this bill that asserts the surrogate will be the legal mother and that her husband in the circumstances would have control or would have parental rights, should I say. So we totally oppose this premise. We believe that it's completely devoid of any accuracy and that it doesn't represent. We believe that it's more or less giving us what we've already seen under the current legislative position that connects rights to someone who we don't believe should actually have parental rights over the children. In many ways, we feel this kind of harks back to this traditional view of the family that has been espoused in this country, where you have mommy and daddy and children. We think that this is clearly out of date. We think that the definition of families in Ireland has changed, and it's high time legislation, including this piece of legislation under the AHR Bill, should catch up. I know, if I can briefly add, Minister Donnelly was recently questioned on the 21st of January on this in the Dáil by Roisin Shortall. And again, he kind of espoused this attitude that this was a great step forward, that this was something that we should be doing, and that's going to dramatically change the law in this area. In reality, I think as we've outlined so far, it isn't that. It's more or less a rebranding and an extra layer of legislation rather, to a system that already exists. We don't propose this. We believe that if it's going to be legislated for, it should be a wholesale reform, such as the one that Yasmin is going to now outline. And I thank you very much for your time. Thank you.
We can see your. Is that the right slide for you?
Yeah, that's the right slide. If you, am I pinned there at the side? I'm not sure. I can't see myself there.
It's coming up for me because you're speaking. That it's coming up.
All the better, even better that I don't have to see myself speak. Good afternoon, everyone. My name is Yasmin, and I will be following on from my colleague Jack. So at this point, we have a clearer picture of what the legal landscape governing surrogacy in Ireland is. We've briefly discussed why reform is necessitated, which will be looked at in more detail by Garrod, I'm sure. And we have now a better understanding of the 2017 Human Reproduction Bill. I would now like to cast the net a little wider. So take a look at some other jurisdictions and outline how they may prove useful to us here in Ireland. These jurisdictions can give us some sort of inspiration on how best to legislate this surrogacy area going forward, but also importantly, they can highlight issues to us in relation to what is not working in their system. And we in Ireland can learn from them. So firstly, across the pond then to the UK law stipulates that the birth mother, the surrogate, has legal parentage of a surrogate child, and this is echoed in Irish law also. The gestational mother then is not bound to pass custody to the intending parents, even if she signed a prior agreement to this effect. The intending parents must apply for a parental order, as outlined in some detail by Jack in relation to Ireland and the 2017 Assisted Human Reproduction Bill, but only after the child is born. Therefore, many intending parents in the UK and Ireland must attend court to obtain their parental rights. The UK, England and Wales Law Commission is in the process of reviewing and amending UK surrogacy law. They have already published material highlighting the issues that exist within current UK statute, many of which are identical to the current issues that exist here in Ireland. And to that effect, the Law Commission has identified issues including, and we have already outlined some of them, the lack of guidelines governing the payment for surrogacy, the challenge for children to identify their surrogate, and the issue of obtaining citizenship born to surrogates in other countries. All of these issues, as I have reiterated, are similarly echoed in the current regime operating in Ireland. So now to move a little further afield than the UK to California, and the Californian court's practical approach towards surrogacy is put forward here today as a way to legislate this area in Ireland, in line with the outcome of the marriage equality referendum in 2015. So the first step then, what do they do in California? The first step is they allow intending parents to obtain pre-birth orders. And what this really allows parents to do is it allows intending parents to be recognized as the legal parents of the surrogate child. This is legally enforceable upon completion of a surrogacy contract and equally is enforceable before the child is born. We've highlighted why, I'll highlight as well and detail why this is particularly important, but I might move on just in relation to time to the second point of what happens in California for the intending parents. What they do next then is they file a declaration of parentage with the Register of Births, Deaths and Marriages, and they have their names registered on the child's birth certificate. The California Family Code ensures that surrogacy agreements, whether commercial or altruistic, are legally enforceable. And this framework allows no room for ambiguity in terms of parental responsibility, nor does it favor the rights of gestational mothers once the child has been born. In terms of our recommendations then, I might just wait for the slides to catch up there, Tony. Perfect. Yeah. So what do we propose? So in terms of the recommendations that we, and by we, I mean Surrogacy for Change, what we propose and what we recommend is the creation of a legal framework to legislate for commercial surrogacy to enable payment to be made to surrogates for carrying a surrogate child. Both commercial surrogacy and altruistic surrogacy would, under this proposed framework, operate in tandem, and that way payment may be received and these contracts would be enforceable. The minimum age for surrogacy that we propose for the surrogate and also for the intending parents is 18 years of age. And why we propose that age is because I suppose that's the age of majority in Ireland. Following on from this, then it's advised that surrogates would consult with a registered medical practitioner. They would undergo a psychiatric evaluation and obtain independent legal advice prior to signing an enforceable commercial agreement. And this is really to protect all of the parties that are involved. And once all of the parties to this contract have consented, a signed copy of the contract would then be forwarded to the hospital where the child is to be delivered, pursuant to the procedure that I have mentioned in California. And why this is really important and why we propose this and put this forward is because this would allow a lot more clarity in relation to this area and would remove some of the uncertainty and ambiguity at what is meant to be a really very special time for the intending parents. To summarize then our presentation and what we propose, surrogacy in Ireland really opens doors for intending parents who don't have the biological ability to procreate themselves. And while these alternative opportunities are a truly wonderful development and really very exciting, they equally create responsibilities for intending parents and for the surrogate alike. But importantly, they also come with an obligation on the state to safeguard and to protect the children that are born as a result of these medical advances. As outlined by Jack, Aoife and Jack, and I mean, frankly, as an overview, the legislation that currently governs surrogacy in Ireland is no longer tenable. The law really should govern society, but in turn, developing societal realities should be echoed in law. And Ireland has seen great change over more recent times, with the definition of the family being more inclusive and realistic of family units now that are in Ireland, more so than ever. And as such, a lack of clarity and protection around surrogacy is discriminating against some Irish families. And I'm sure Garrod will mention this more. No family unit, is our recommendation, should have any more or less protection than any other family, because I'm sure we're all aware that families in this day and age come in all shapes and sizes. And as a parting comment, if I may, a country in general and Ireland in particular can truly be judged by how we protect our most vulnerable, and who more vulnerable than children. And we just need to do better. So on that note, I, and on behalf of Surrogacy for Change as a whole, we would like to take this opportunity to really thank you for your time and for your attention. And I will now pass over to Maeve Delgary.
Hello, everyone. Thanks so much for that. That was brilliant. And just so I think we're really lucky to have people who are, junior and starting out in their careers, really taking on this challenge of getting to grips with surrogacy. It's important, and I think that's a good point from Yasmin there about it's not just to help the people who are affected by this and the children and the families, but also to show believes that all families should be protected and treated equally. So you may remember me from other things such as last week's series, and there I was being the Outlaw host, but today I'm here as Equality for Children representative. I'm on the legal team, and I'm delighted now to introduce Garrod Kenny-Moore, who is a board member of Equality for Children. And I'll just hand over to Garrod to introduce himself and his family. And the best part of these talks is getting to show pictures of the children. So I'll try and do that in the background while Garrod's speaking.
Okay, thank you, Maeve, and thank you to the guys from Surrogacy for Change for that presentation. So as Maeve has outlined, my name is Garrod Kenny-Moore. I'm part of the Equality for Children group. I got involved pretty much from the beginning. And as you can see there from the pictures, I'm the proud father of two amazing children, Sean and Mary, who were born via surrogacy back in 2018. Just to kind of give a brief background to the story of our children, we as a couple tried initially to have our children back in 2014 when we travelled to Canada to participate in a surrogacy program there. the model in Canada is very similar to the Californian model as outlined by Yasmin. And we were very hopeful that we would have our children there, but sadly, for very unknown reasons, medical reasons, the IVF process that we undertook didn't work. We tried 4 different embryo transfers, none of them worked, and we kind of gave up on the journey. We were kind of penniless. But anyway, an angel came along in the form of a friend of mine who I had worked with back in London in the early 2000s. She had kept in touch with us about her story in Canada. And when she realized the stress and the impact of not having children on us, she agreed to carry our kids for us. She was based in the UK, but she came forward and said she'd actually carry our kids. And originally the plan was to have 1, but then she bizarrely suggested that she'd like to try and carry 2 kids, which I can't explain, but she thought it was a good idea. And we're delighted she did that because we have our twins now. So the medical background is that we used a clinic in California. As you probably know, Irish clinics will not facilitate surrogacy journeys. So again, we had to turn to overseas to do that. The embryo transfers worked first time around, and Sean and Mary arrived in September 2018. So that's a little bit about us. We live in North County Dublin, and having kids is the best thing that's ever happened to us. But yeah, we're in that little horrible legal position that Yasmin, Jack, and the 2 Jacks and Eve outlined. We're very much vulnerable, and our kids, we feel, are very much treated in an inferior way by our state because of the fact that they have 2 daddies as opposed to a mommy and a daddy.
Thanks, Garrod. Thanks for sharing. It's always important and really helpful, I think, for people to hear the personal stories, even though it's such a big and private thing really to share. So thank you. Maybe you could elaborate a bit more on what the difficulties, you're saying you don't have legal protection, your family doesn't have legal protection. What are the practical implications of that?
The practical implications are numerous, but like maybe to put it in summary, they began the minute our children were kind of conceived through the hospital system. It was always the surrogate who was considered to be the patient, and we had no ability to make any input into the decisions within the hospital. And even when the children were born, again, we had no ability to make any input to those decisions. But in our case, we had a very healthy relationship with our surrogate, and she was able to, take us aside to get our input, and then she would make the formal request of the hospital. But even when the kids came to our house from day 1, which was the ideal from the beginning, as soon as we went to apply for their PPS number, because the state assumes that there's always a legal mother present in the lives of the child, the form that we had to fill in asked for all sorts of information about that mother. And we didn't have it, and we didn't really want to actually give it, even if it was available, because our children don't have a mother. They have two other parents. So like getting the PPS number involved us having to talk to the very kind and generous and warm-spirited person at the PPS office. But she said, look, guys, I'm really sorry. I'll need to escalate this to our management, and you'll have to write a letter to outline the background. And once we did that, we were able to get a PPS number. But then we had the same problem again when we applied for child benefit. The state assumes there's going to be a mother applying for that, or a father certainly who has guardianship, and we couldn't do that. Getting the passport involves hurdles. Medical procedures involve hurdles for us because the non-biological parent has no right to participate in even simple things like vaccination. So when you're involved in a surrogacy journey, particularly as a gay, well, not actually particularly, when you're involved in a surrogacy journey, regardless of the gender of the parents, the power lies with the surrogate. And even in our case, the surrogate was a gestational one. It was always assumed afterwards that she would be available to sign documents and forms for PBS's, child welfare, or child benefit, passports, school enrollment, whatever. It's everywhere that we turn when it comes to interacting with the state.
And you mentioned there about the non-biological father. So is there a difference? Maybe there wasn't at the start, but is there a difference now between the non-biological fathers linked to your children and the biological father?
Absolutely, yeah. So the biological father has the right to become a legal parent with the consent of the surrogate, typically. The non-biological father is basically a complete and utter legal stranger to his child or her child in the case of an intended mother. until the child reaches the age of 2. And at that point, the non-biological parent can apply for guardianship of their child. But guardianship, as I said, it's absent for 2 years. So all those decisions around passports and medical treatment and creche or school enrollment and pickups, the non-biological parent has no right to participate in those. And then even when guardianship is granted, it dissolves at the age of 18. So when that child turns 18, they once again become a completely legal stranger to their parent. So that if the parent turns out to need medical care in an older age, that child has no right to participate, no automatic right to participate in that care or to give consent for various different treatments for their parent. And so you're back in the position where you're relying on the goodwill of the person you're meeting at the bureaucratic level to allow, for the child to maybe participate. So you're always kind of hoping that when you meet the state in a bureaucratic setting, that the person you're talking to is going to be reasonable and willing to accommodate a family like yours. So the non-biological parent gets guardianship after 2 years, but in that 2 years, lots of important decisions are often made that they have no right to participate in.
Yeah, and I think has been highlighted by our other speakers as well, of it's the worry that maybe you'll get someone who doesn't agree and they'll put a barrier, a legitimate legal barrier in your way. But also, I suppose, even if the things you're struggling to do, get your PPS numbers for your children, work out, it's that extra stress and extra level, and it has to go through multiple people where you're trying to raise twins, you have a lot on your plate already. So it's just unnecessary.
Yeah, and you're having to tell this story that it's completely irrelevant at this point. How our children were conceived continues to be told. Obviously, I'm telling it here now, but I mean, in a bureaucratic sense, it's something that I have to ring up and, tell the story once again, how they all came about. It's just completely unnecessary. And yeah, I often have to write these. I actually have just a document saved on my computer at this point that I kind of cut and paste from when I'm trying to send these letters off to whether it be a school or to be a doctor or whatever it is. You just constantly have to tell this story that at this point is irrelevant.
Yeah. Could you talk a little bit more about the two processes, maybe the guardianship process and then the process that the biological parent can go through to get legal recognition?
Yeah, so the biological parent can seek, as far as I am aware, guardianship of their child pretty much from the beginning of the child's life. In order to go through that, they would need to make an application, and it would require the consent of the surrogate. The non-biological parent's guardianship order can only commence at the age of 2, as I mentioned, and again, it needs the consent of the surrogate and the other biological parent in order to proceed. In terms of the practicalities, it's actually quite straightforward, but from my own personal perspective, we as a family don't like the fact that we have to do this, that we have to prove to a court or to a registrar that we are fit to be considered as guardians of our own kids. And even when you do get the award of guardianship, you feel that, well, what have I actually achieved by this? Because anybody who's involved in our child's life, whether it be a close relative or a close personal friend, can actually apply for guardianship. So even though it does bestow on you certain legal rights that are required, the fact that it's something that can be made available to anybody who has an involvement in the child's life kind of diminishes it in terms of the sentiment associated with it. So when we got we're in the process of applying for guardianship of our kids, it's been slightly delayed because they've just turned 2 and then we've had the whole COVID lockdown. We won't be celebrating guardianship because, as I said, it doesn't signify the special relationship that exists between a parent and their child, and it's not parental rights.
Yeah, that makes a lot of sense to me. The 2 years has been mentioned a few times, and that seems like a long time. How long is it actually when you're raising children? You probably feel like they've been around forever.
Yeah, it's certainly, when they came into our lives, we were responsible, not from a legal perspective, but from an emotional perspective, for raising them from day one. And, you know, it's the best thing that's ever happened to me and to my husband. They're just such a gift, and you don't really understand it, even though you hear it, until they actually get here. But then every so often, as I said, you try to do something that's considered normal for every other family, such as bring your child to vaccinations, or, you know, bring your child to an important medical appointment. And then you're jolted back into the reality of the bureaucracy and the way bureaucracy views your family. So, you know, we have to think about things like, I'll give you a very simple example. When our daughter was born, it was suspected she might have a heart condition. Thankfully, she didn't. It was fantastic news. But we had to think about, well, we were told by our GP, look, the biological parent should go to that appointment, because he will be the person who will need to sign any consent forms if further medical treatment is needed. So things like that, you know, that's already kind of a bloody stressful thing. But then to have to think of this other layer of, well, like, who needs to be there? And, you know, being a parent, as I said, is superb. It's just, it's indescribable. But even, you know, everyday things like registering your kids for school, our school sent out a form, you know, name of mother, name of father. We had to write back a letter saying, well, this is our story, you know. So it's an amazing bubble to be in when you become a parent, but we get kind of blown out of that bubble every couple of months, and something new involving the children's just maturing requires us to actually step out and kind of take the practical, pragmatic perspective. You know, only the biological dad can do this in that first 2-year period.
Yeah. Yeah, because I think that sometimes gets overlooked, like how it makes you feel. It's not just about that you have to do these things, but it hurts. It's not nice.
It's also, you look at your kids out playing with, you know, their cousins or, you know, the neighbors on the green, and you think that they're the most superb kids in the world, but then you realize, well, actually those kids beside them are actually treated in a completely superior way to my kids. And that really hurts, because as a parent, you know, the last thing you want is for your child to experience discrimination. But we feel that as parents. They currently don't feel it, but they will if things don't change. You know, when they're going on a school trip, you know, they'll need parental consent, or they'll need for the guardian to tick that they're a guardian and not a parent. So they'll see that, and you just don't want them to feel that in a country like this where it's not necessary.
Yeah. And maybe just finally then, before we move on to questions, and I see they're coming in the chat there, what's the best thing? What's your favorite thing about being a parent? Oh,
I could be here all day. And it changes from day to day, because, you know, they're going through lots of development right now. They're 2.5. The best thing is just seeing them first thing in the morning, and they wake up and they're full of ideas. You know, I'm struggling to get out of bed because it's some forsaken hour of the morning at 6:30 or whatever when the two of them wake up. And you walk into the room and they literally they sleep in the same room. They're bouncing up and down in their cots. Bring me downstairs, bring me downstairs. You know, they're just full of vibrancy from the minute that they go. Their imaginations are running riot at the moment. We took a train trip for the first time ever when lockdown ended a couple of weeks ago into Dublin. And since then, every day, no matter where they are, they're on a train and they're describing it in detail, how they're on the platform in Connolly, and they're just bonkers, and it's brilliant.
That sounds great. Yeah, lovely. Well, thanks again, Garrod, for that. And I know there's questions for you in the chat, and there's also questions for our legal speakers, Surrogacy for Change. Maybe just to say at the outset that, you know, the guys from Surrogacy for Change managed to cover, you know, really large amount of information there in the short time we gave them. But we will be putting up the recording of this webinar on our website. We will also be making the report that Surrogacy for Change prepared available, as well as the slides from today. So, you know, you can look at it again and absorb kind of, you know, in your own time. So I see there's a question in the chat, about the cost of surrogacy, and Mark, thanks for answering that for people. I think it's interesting that, you know, it's hard to kind of nearly find information on this, and we've found that through these series that people are asking each other questions, and, you know, there's a lot of practical things. Garrod, do you have any point to make about the cost, or, you know, any? I don't believe there's any provision to make state-funded surrogacy available.
No, the cost depends on the location that you travel to. For LGBT plus couples, which are primarily when you talk about surrogacy, it's gay male couples. There are really few global locations that will allow for surrogacy journeys for gay couples. So most gay couples that I know through my online networks have either participated in surrogacy in Canada or the United States. And the cost is eye-watering. I mean, we literally had to beg, borrow, not quite steal, but certainly sell things to get the money together. Depending on the location, Canada is about 70,000 euros or thereabouts, but that assumes everything works according to the plan, and that covers your clinic fees, your surrogacy compensation. Surrogacy is considered altruistic in Canada. There's very strict guidelines on how much money can be covered with an altruistic surrogacy, and it also covers legal fees. The US is about a little bit more expensive for the clinic piece. I can't comment on the surrogacy compensation in the US because we didn't do that. We had, as I said, a friend from the UK. But as I said, for LGBT couples, primarily gay male couples, I'm speaking about, Canada and the US are the only options. And you're talking, as I said, north of 70,000 euros. The second part of your question, no, there's all you can do to recover some of the cost is claim back the cost of your medical treatment for your surrogate. In other words, the embryo creation and the IVF and the embryo transfer against your end of year tax bill. So you'll get a portion of that back, about 20%. But yeah, for other couples who are involved, I know there's some heterosexual parents or intended parents on the call. There are locations that are lower cost, such as Cyprus, Ukraine, but I couldn't comment on the costs there because, as I said, it's not something we were able to explore.
Mm-hmm. And just maybe before we go on to a legal question for Surrogacy for Change, were you, either of you, entitled to parental leave? Garrod, you or your husband?
No, so there's no automatic right. So I think maybe it's maternity. So in terms of, when our child was born, neither of the employers that we worked for had any right to offer, or had any obligation to offer us any form of leave to care for our child. They couldn't offer adoptive leave, they didn't offer adoptive leave, they didn't offer maternity leave. So basically the decision we made as a family was that I would give up my job and be the full-time stay-at-home parent. We are allowed to apply for, the biological father, that is allowed to apply for the state's parental leave designed for men. I think it's called parental leave, which is a couple of weeks per year. But in terms of the leave that people typically get at the birth of a child, we didn't have the right to apply for that, and it wasn't offered to us.
Does anybody from Surrogacy for Change know whether in other jurisdictions there is any provision for that? And I don't think, is it part of the IHR Bill? I'm not sure.
Within the IHR Bill anyway, from what we've seen, there's no provision for parental leave as it will be now. I don't know if Yaz wants to talk about other jurisdictions.
Yeah, as for other jurisdictions, I mean, it's the same kind of that applies that we were looking at when I talked about California. You would get parental leave in California as if it were any other child born in any other type of way, which definitely would be something that, in our opinion and in our proposal anyway, would be needed in this country.
And there was a message through in the chat there about international surrogacy, and from what I understand, that's not part of the IHR Bill. They're just looking to regulate domestic surrogacy. And I know, Jack, you answered it in the chat, but did you want to expand any more on international surrogacy?
Well, again, yes. So like Yaz has kind of talked through the different jurisdictions and the way things are done differently. But obviously, she did mention the stateless children and the precarious position that many people are left in when it comes to trying to negotiate that hurdle. So no, there isn't, is the short answer in the IHR Bill. It's uniquely focused on Ireland, which, and not only that, but it's clearly been heavily informed by what already went before it, which again, leaves people in the position that they are now. As I kind of mentioned briefly, what our proposal would envisage is that as parental rights will be established to the intending parents from the outset, or very early on in the process of creating the surrogacy contract, that were those to take place abroad, that the child will be entitled to Irish citizenship through parentage, as is the case with people born outside the state to Irish parents normally. But yeah, I think another point that maybe I'll just stress on this, and Yaz might want to come in on it. When we talk about kind of commercial, and I know that there was costs analysis, and Garrod had to answer questions about costs, we don't necessarily, like, we're not proposing this wholesale kind of expensive type system. I suppose we look at the commercial side of things because we believe that this is a means of informing how we view this relationship, that this is a relationship between an intending parent and somebody who's providing a service, albeit it's a very unique service. But we don't kind of support this kind of where, as Garrod mentioned, you've got these highly expensive systems that are taking place. We probably would look at some sort of reform or restrictions on costs. But as I said, this is with a view to looking at the relationship as between two intending parents and somebody who's providing a service to allow them to have children. I don't know if one of my colleagues wants to come in on that at all.
Yeah, just to come in on it there, like what we're proposing, as Jack says, it's not commercial in terms of, I don't think you're going to see surrogacy clinics popping up around Dublin or the major cities for profit. But I know, Garrod, you said there, like your friend stepped in and afforded you the opportunity to have a child through surrogacy. But if you look at the current system in Ireland, let's just say that woman was out of work, she didn't have a car, you had a lot of money, you wanted to buy her a car. That's currently illegal. You couldn't buy her the car. So she was able to help you with what you and your husband wanted. But if you had enough money to buy her a car, currently that's illegal. Or if you wanted to buy her a nice holiday or something. When we say commercial, we're not talking about people saying, yeah, I'll be your surrogate for €100,000 cash. But, you might be able to give, within certain limits, as Jack say, a certain amount of money if you wanted to. And the beauty of it is that our commercial surrogacy submission will also work in line with altruistic surrogacy that's already here at the minute. So if you didn't want to pay and you wanted to continue with the current way that things are running, well, then that's fine as well. But the option is open. And it's all just about having options for people and not limiting it, because everybody's circumstances are different.
Good point. Yeah. Garrod, did you have anything you wanted to say on either international surrogacy or the compensated model?
Certainly in relation to the compensated model, I mean, I think it has been touched on already by the speakers. There will be scenarios in a surrogacy arrangement where expenses do occur. What happens if your surrogate becomes pregnant and towards the end of her pregnancy needs to stay at home from work because of a health issue related to the pregnancy? There has to be some ability to offer payment. And what you want is very, very clear guidelines, I feel, on what's acceptable in terms of the categories of payments that can be made and then the actual amounts associated with those categories. The reality is that it is happening. Couples are engaging in surrogacy and trying to arrange and kind of feel their way in the dark. So there has to be some sort of guidelines in place so that people don't inadvertently break the law. Because personally, I didn't actually know that it would be illegal for us to offer our surrogate a holiday, because we have every intention when lockdown finishes of giving our surrogate a chance, because she didn't want to go on holidays after our kids were born because she just wanted to stay at home and be with her other children. But she did want to, we had always said that when lockdown comes to an end, we were going to give her the opportunity to go on holidays and at our expense if that was something she wanted to do. So I'm glad you told me, because I didn't know that. So like that's, that would have been a very, simple arrangement between two friends and probably would never have been flagged by the authorities. But, I genuinely didn't know that would be something that that could get us into trouble. So yeah, it's a completely grey area, and it's the elephant in the room. So it absolutely requires some form of guidance from the lawmakers.
Thanks, Garrod. There's another question in the chat there that people may have a view on, and it might tie into what Surrogacy for Change has been doing with their report since it was published, and what kind of response you've got, or what appetite do you think the government has for legislating on this? Because there's a question wondering whether Kyle and his husband should wait until this is all sorted out and legislated for in Ireland, or should proceed with whatever options, expensive as they are available at the moment.
If it was me, I think I would proceed at the moment, because I don't see this overnight. I don't see it happen within the next 2 or 3 years. And even if a bill does pass, I don't see it containing the correct provisions. And an act is going to have to be passed, unfortunately. In terms of engagement that we've had from the government, we've had some very good engagement from some very prominent TDs. I'm not going to mention any names. We've had some ministers, again, I won't mention any names, but very good reports back from them. they're happy to look at it. They're happy to take our feedback on board. They've said they're going to put it onto the programme for government. Now we await to see the programme to government to see if it's actually going to make it on. Equally, we've had an awful lot of people who've just kind of stuck their head in the sand and said surrogacy, not my thing, don't want to get involved, which is kind of a shame, really, because it may not affect people directly, but if it's affecting people in the country, really, something needs to be done about it.
Just to come in on that as well, if I might, while we have heard an awful lot of really good things from ministers and TDs and all the rest of it, to really answer your question in short, I wouldn't hang my future options on the words of people that haven't actually made any definitive decisions or anything else. So unfortunately, I think we all face a circumstance where it would be probably the best thing to act now as opposed to wait for something that should potentially happen. But there are no assurances in the coming years.
Just to put a bit of an anecdote on that. When we first looked at the idea of having kids back in 2014, we did approach our family solicitor, who wasn't a specialist in surrogacy, and his advice to us was, guys, I'd really wait until kind of the legislation comes through. There is things in the pipeline. Had we waited for that, we would now be 6 years later without our kids and with no sign of it being resolved, and life moves on. So don't wait. Go for it, because I don't think this is ever going to be an issue that decides an election. So therefore, politicians will never give it the focus that we feel it merits.
Thanks, Garrod. I think that's good advice, Kyle. There's a question from Fiona Duffy here, who is an expert in this area, so no pressure, but she's looking for your view on lobbying for parental rights for people that have gone through surrogacy prior to the legislation coming in, so retrospective applications. Do you have a view on that?
I think absolutely. I think the whole point and the whole premise of all of this is that the law has to really, align with reality, and the reality is that these intending parents are parents, full stop, whether that's retrospectively before legislation is created or after. So, on behalf of all of us in Surrogacy for Change, I definitely think that that would have to be lobbied for, to give them the rights as parents that they deserve.
Yeah, and then Kyle, that might help you in your situation if you do go ahead. That it'll be, once the legislation does come in, there'll be a look back for people that have already have children. And there's just one question there before I hand back to Tony. Somebody might be able to answer, will the surrogate be entitled to maternity leave, especially if they're recovering from a C-section?
At present, is it?
Yeah.
Yeah, well, from our research, yes, they would be entitled to that at present. But I suppose what we were more focusing on was the intending parents. I mean, they are parents for all intents and purposes. They have a new child, and it's such a special time. It's really important, we believe, that they have that time with the child, should they want to have that time. But yeah, to answer the question in short, the surrogate would have that time available to them.
My understanding is that Equality for Children are involved in a group called the AHR Coalition and looking at this legislation and what to recommend. And there's surrogacy groups involved with that. And our briefing paper, I think, does include that the surrogate mother, even though we don't agree with Surrogacy for Change that she should not be the mother on the birth of the child, that person who has given birth would still be entitled to leave. We don't recommend that. That of course would happen. So thanks everyone for your questions. Thank you to our panelists for answering the Q&A. Thanks everyone for attending. And on my behalf now, I'll hand back to Tony.
Thanks, Maeve. Just to echo your words, thanks to Garrod and the Surrogacy for Change team. For me personally, these sessions are hugely informative. I mean, when the idea for the series of events was initially proposed earlier in the year, I totally admit that my knowledge on some of these issues was very limited. And it's been so interesting to hear from our legal speakers like Surrogacy for Change, but also from our speakers like Garrod, who've shared, I suppose, the really personal side of the challenges that are faced by LGBT plus families in Ireland. And I think probably a common theme amongst these events so far has really been, a lot of progress has been made, but there's a lot more progress to be made. And I think that's why events like this are so important. And, kudos to groups like Surrogacy for Change and Equality for Children for the work they're doing and driving these sorts of issues forward. Just to wrap up, I know that many of those who are joining us today would have joined us for our other events in the series, but just a reminder that if anyone didn't make it to any of those, they are available along with this webinar, or what this one will be shortly, on the outlawNetwork.ie website. Also, if anyone has any questions that they didn't get to ask today, please feel free to get in touch with us here on Outlaw Network, or alternatively get in touch with Equality for Children, and either group will do their best to get back to you. Finally, just want to wrap up by saying a huge thanks to Maeve Deleghy. I mentioned that Maeve was wearing 2 hats earlier, but that doesn't really scratch the surface in terms of the work Maeve does in these types of various groups, and to bring various groups like Outlaw and Equality for Children together. So a big thanks to Maeve for putting this series of events together. And with that said, I think I'll leave it there. Thanks very much everyone for joining us today, and have a good day.